From the Toronto Star, I'm Saba, and this matters. A recent court decision in Ontario could really change things for those who've been laid off during this pandemic, and it could also mean thousands of lawsuits in the coming years. Last year, thousands of people lost their jobs as the pandemic hit businesses across Ontario, and it was a confusing time. Lots of people were put on temporary layoffs, which were then extended and merged with the government's COVID-19 emergency leave, which, although it aimed to avoid permanently laying off workers, also meant they didn't get severance pay, even as their unemployment stretched on, as we saw the virus rage on. Employment lawyers warned that these amendments could create problems. Workers could be exploited, businesses could be sued. Recently, an Ontario judge ruled just that in a case, concluding that a COVID emergency leave of an employee was actually a termination, which means they can sue for constructive dismissal and severance pay. So, are thousands of employers now on the hook? I'm joined by the Star's business reporter, Rosa, who's going to answer that and explain many more things about how constructive dismissal works during a pandemic and what this particular court judgment means for both employees and employers. Hi, Rosa. It's good to have you back on the podcast.
Thanks for having me.
So first of all, Rosa, you mentioned in your piece that some employment lawyers started saying last year that the temporary layoffs during the pandemic might actually be constructive dismissal, which changes things a bit. Could you explain what constructive dismissal is and what that would mean for both employers and employees, as opposed to the temporary layoffs?
Yeah, so it's really interesting. I looked back. I actually wrote that piece March 24th, 2020. I was joking to one of the lawyers who I interviewed for both pieces that this article is him sort of saying, I told you so. It's not that simple, of course, but certainly interesting to see that play out more than a year later. So a constructive dismissal is something in the Employment Standards Act. It obviously existed before the pandemic. It's when an employer does something, whether it's a temporary layoff or a reduction in hours or creation of a hostile work environment, that is considered as essentially terminating the employee by giving them no choice but to leave. So, for example, if they do a temporary layoff in a legal way, because it can be done illegally, we'll talk about that in a sec, but the layoff period exceeds the number of days allowed as per employment law, the employee has been constructively dismissed or terminated and should be receiving severance pay.
And does the law allow for temporary layoffs? What are the rules and conditions around that?
So temporary layoffs are allowed in many provinces, but only for a certain period of time. So in Ontario, it's 13 weeks or up to 35 weeks if the employer keeps paying benefits. And then if the time limit passes and the employee hasn't returned to work, again, they're considered terminated and owed severance pay. However, many people don't know that employers can actually still be liable for severance pay regardless of the time period, unless the employee actually agreed to be temporarily laid off. So that agreement can either be in their employment contract, and it is in some contracts, you sign it, and there's a clause in there that says, my employer has the right to do temporary layoffs under certain conditions, or they can sign that kind of thing at the time of layoff. So the employer can talk to them about the temporary layoff, they can agree to it, and usually there'll be a signed document. Without such a clause or an agreement, the employee can sue for breach of contract or wrongful dismissal, regardless of how long the layoff period is. And in the case of the pandemic, regardless of whether that temporary layoff period was bridged into the temporary emergency leave.
Right. I can see how that can leave room for a bit of confusion regarding this. And as you mentioned, things shifted during this pandemic from temporary layoffs initially to eventually a lot of confusion around whether or not people would ever be able to return to their work. So it's changed a lot of things for both businesses and employees, right?
Yeah. So when the province realized that those temporary layoffs were going to be longer than the law allowed for, and I mean, again, at that time, obviously, when everyone was being temporarily laid off, we had no idea how long this was going to be. But at a certain point, the province was like, all right, it's going to be more than 13 weeks for a lot of people, or 35 weeks, depending on, again, the contract. So they introduced an infectious disease emergency leave, which retroactively changed all COVID-19 related temporary layoffs into emergency leaves of absence. So that meant that the temporary layoff periods were bridged into emergency leaves, meaning they could be a lot longer without repercussions for the employer, at least in theory.
And now there's been a court decision, which is quite significant in this respect. Tell me more about the background of the case and the Ontario Superior Court decision that you talk about in your article.
So this case involves a former employee of an ophthalmic clinic in Cambridge, Ontario, who was laid off early in the pandemic. Like many people, obviously there's specifics to the case, but overall, it's very similar to what happened to probably thousands of people in Ontario. So her temporary layoff eventually became infectious disease emergency leave under the Ontario government's pandemic regulations. But in this case, the judge ruled that actually she had been constructively dismissed and was eligible to sue for severance.
And what does that mean in the larger context? Did the decision set a precedent and prove these lawyers' predictions right? What do they say? Could we be looking at a landscape of lawsuits in the coming future?
So, that depends on who you ask. This is just one decision. It's just the first decision. And, the employment experts that I spoke to said there are already a lot of similar cases moving through the courts. This one, it takes a while for these things to happen. And there's already a bunch of cases that are going to be decided in the coming months. Not all of them are going to go the same way. It depends on the judge. It depends on the specifics of the case. But this particular case could be an indicator that many of them will go in the same way. And some of those experts think that this decision could also prompt more laid off employees to take to the courts in the hopes that they might have a similar decision.
We'll be right back. What does this decision say about the government's emergency leave regulations, that they didn't work the way they were intended to?
So this first decision shows that any employer who temporarily laid off their employees during the pandemic could still be liable for severance or more if they did not have a temporary layoff clause in their contract or in a separate agreement. The experts I spoke to said that that's actually quite common. There are certain industries where it's more common to have those clauses. Unionized workplaces, for example, larger businesses, certain industries like construction, I believe. But, there could be a lot of employers who are in this situation. And in that case, the emergency leave enacted by the province does not protect them from being liable because the initial temporary layoff was not legal in the first place.
So are we looking at a legal loophole of sorts now? Can employees who were on emergency leave also sue their workplace for being laid off? And under what circumstances could that happen?
Again, if temporary layoffs are not mentioned in their employment contract or in a separate agreement that they explicitly signed or agreed to, employees may be able to argue that they were constructively dismissed instead. That is the loophole, so to speak. It doesn't guarantee you a decision in your favor. There are some other factors. Those are the factors that you're looking at, yeah.
And like you mentioned, there's different opinions from experts on this. What is this legal fraternity saying about how this could look? Could this mean years of employment litigation? And what would that mean for both employers and employees who've been trying to regain lost ground after the pandemic hit them so badly as well?
It's really too early to tell. This is just one decision, and it could also change in higher courts. Some of the people I spoke to think it could make its way to the top court in Canada. There's already lots of similar cases making their way through the courts, as I mentioned, and the more decisions we get, the clearer it will be what that impact could be on those cases, right? So again, it's just the first decision, could be an indication of things to come, but it's too early to tell what kind of effect it's going to have on all those other cases.
Rosa, under these circumstances, there could be potential employers who ended up exploiting the merging of the temporary layoffs and the emergency leave, and employees suffered. And we've all heard some stories around that, especially affecting low-income workers in the hospitality sector, for example. In that case, what legal options do employees have?
It's called a wrongful dismissal legal claim. Wrongful dismissal is used for a number of circumstances, and one of them is constructive dismissal. Unfortunately, not everyone can afford a lawyer, can afford to go through that. However, there are actually some legal firms that offer their work without payment upfront. So meaning you only pay them if they win the case for you. So there are firms out there that advocate for those people that cannot necessarily afford an expensive legal case. But yeah, that's how the system works. And that's what they're supposed to do if they think that they should be owed severance that they didn't get.
Could we see the law around this particular situation evolve and adapt to the rather exceptional circumstances of a global pandemic?
Certainly. The experts I talked to did point out that other judges might be more sympathetic to the position of the employer, at least in some cases, given the extreme circumstances of the pandemic. So as I mentioned, a lot of these cases are very similar, but, employers have really struggled. They might have had no choice. And I think it really depends on the specifics of the case, but also on the judge and where they stand. So some judges might be less keen to put the employer on the hook for severance pay for that reason. After all, the Employment Standards Act doesn't mention anything about a global pandemic.
Stepping outside of it a little bit and looking at the bigger picture, we know that the pandemic has created a before and after scenario for all of us. A lot of things will never go back to the way they used to be again. Do you think this has also significantly impacted employment practices and the dynamics between employers and employees? And what can we see come out of this and hope that it's actually a shift that protects everyone and exploits no one, ideally?
Well, it's certainly possible that coming out of the pandemic, there's going to be a lot more awareness of this particular thing, but also, many other issues in the workplace. So it's totally possible that more companies will start adding temporary layoff clauses in their contracts. That's not necessarily a good or a bad thing for the employee, but at least it does set out what happens, right? So they can read the contract and know exactly what their rights are, as opposed to, not having that language in there at all and not necessarily knowing what their rights are unless they're reading the Employment Standards Act, right? So depends on how the clauses are written. One of the experts I spoke to, who does tend to represent, more low income, more precarious workers, said that he hopes such clauses are written in a way that does protect the employee as well as the employer. Not totally sure what that would look like, but definitely an interesting thing to look into if it does become more common. That's just one of the many things that I think could change in our new employment landscape, especially as we start to reopen, fingers crossed. I think that workers and the public are a lot more aware now of employment issues that existed before the pandemic, whether it's, low wages, lack of benefits like paid sick leave, or just the general precarity of so much of the work that goes on around us and has been called essential during this time.
That was very helpful. Thank you so much for your time and your insight, Rosa.
Thank you.
I was talking to the Star's business reporter, Rosa Saba. That's it for today. Thanks so much for listening. This Matters is hosted and produced by me, Saba, Adrian Chung, and Raju Munter. Produced and mixed by Sean Pattenden, and our director of programming is JP Fozo. Our show theme music is by SoCalled, and our episode music is by Mike DeAngelis. We want to hear what stories matter to you. Please send us comments, questions, or ideas to thismatters@thestar.ca. Please consider supporting the journalism the Toronto Star newsroom does at thestar.com. And don't forget to subscribe to This Matters on Apple Podcasts, Spotify, or wherever you listen to your favorite podcasts. Let's talk soon.